Supreme Court of the State of Colorado is now in session. Chief Justice Coates presiding.
Thank you. Please be seated. We're here this afternoon for oral argument in the case of People versus Janis. We've scheduled this for 1 hour. If you haven't been watching, I've been warning everybody or asking you to introduce yourself and say who you're representing at the mic, and then try to talk generally in the direction of the mic so we can get that recorded as well. Looks like you're both ready. Counsel for the petitioners, whenever you're set.
Good afternoon. May it please the court. My name is Carmen Moraleda, and I represent the people. My attorney registration number is 34852. Hope this is not too loud. Is it a bit loud?
It's okay.
It's okay. Okay.
It can never be too loud for
Never.
me.
Alrighty. The question before this court is whether a waiver of the right to be present at trial of a defendant who is present in the courtroom when counsel informs the trial court that defendant wants to absent herself during a portion of the trial requires a formal on-the-record advisement as the only means to determine the validity of the waiver when the totality of the circumstances shows that the waiver is valid, and the answer should be no. To begin with, the Constitution doesn't require a formal colloquy on the record to establish a valid waiver of the right to be present at trial. For example, a formal advisement is not required when a non-custodial defendant voluntarily absent himself after trial has begun. A formal advisement is neither required when a non-custodial or custodial defendant persists in disruptive conduct and after being warned by the court, or when defendant creates a medical necessity in order to absent himself from trial. So a formal advisement should neither be required or be necessary to effectuate a valid waiver when defendant, whether in custody or not in custody, is present in the courtroom, and the trial court can determine the validity of the waiver. This court in People v. Mosey, M-O-Z-E-E, distinguished between the waiver of the right to testify and the waiver of the right to remain silent. And it held that while the waiver of the right to testify requires a formal advisement, the waiver of the right to remain silent does not. This court reasoned that the decision to testify is subject to some kind of tension or conflict between counsel who might not want defendant to testify to decrease the likelihood of a conviction, and defendant who might want to give his version of the events to the jury. This court noted that that tension or conflict is not present when defendant chooses not to testify. So similar to Mosey, we are asking this court to conclude that the absence of a formal advisement does not automatically invalidate a waiver of the right to be present. The right to be present is more akin to the right to remain silent than it is to other rights for which formal advisement and procedural safeguards are required, those being the right to testify, the right to plead guilty, and the right to waive counsel.
While you're drinking, can I ask a question? What is the purpose of a written or a on-the-record waiver? What does it serve?
Well, it would serve to make sure that the waiver is knowing, intelligent, and voluntary. And it would definitely, it would facilitate appellate review, but we're simply asking is that it should not be essential to a determination of a valid waiver when the trial court can determine that the waiver is knowing, intelligent, and voluntary under the totality of the circumstances, particularly when you have a defendant who is present in the courtroom.
All right, thank you.
Ms. Moraleda, good afternoon. You've referred a couple of times to the defendant's presence, and I guess I'd ask you to address the facts of this one. As best as I can understand the record, the first time counsel raised the issue, it was done at the bench, presumably out of earshot of the defendant. The second time, Ms. Janis is already out of the courtroom. The counsel comes back in and says, if it's a choice to either stipulate or stay out, she wants to stipulate. Does that make this any different? I mean, the cases that deal with counsel, the defendant was in the courtroom, the defendant hears what the lawyer says. Here, it's not so clear to me the defendant necessarily heard. Now, I suppose there's circumstantial evidence she understood what was happening. Could you address that?
Yes, so let me clarify. So on the first day of trial, February 24th, this is the first time that, defendant was present, and this is the first time that counsel informs the court that defendant has been diagnosed with PTSD. And then counsel and their expert have discussed the issue, and that they think that if she cannot handle it anymore, it might be a good idea to allow her to be removed from the courtroom or to absent herself. She was present in the courtroom, but yes, again, this happened at a bench conference. So the next day, on the 25th, and by the way, that day they discussed how they would handle this. So they agreed that the best way to do it would be for defendant to inform counsel, and then counsel would tell the trial court that she wanted to leave. So that's exactly what happened on the 25th.
Is there any evidence that on the first day Ms. Janis heard any of this?
No, Your Honor, other than she might have been seated at the table and the conference happened at the bench. So the next day, the 25th, right before the victim's testimony, defense counsel informed the court or asked for permission to approach the bench and said, my client is very uncomfortable. She would like to leave the courtroom now. This is page 115 of the transcript to February 25th. So, and then the court allowed the jury to leave the room to address the issue. And then the prosecution, so at this time, she was still in the courtroom. The prosecution said, Your Honor, before defendant leaves, I would like to make a record that she's leaving voluntarily the trial at this point, and no one is forcing her to do so. And defense counsel said, we've already made this record. So at that time, we are to assume that she's allowed to leave the courtroom, but she was present.
And those comments are in open court, not at the bench?
I would agree that those were in open court,
Okay.
but I can't be certain. And then she's allowed to leave. And then the prosecution said that the victim needs to identify the defendant. And of course, defense counsel said that I cannot stipulate on behalf of my client for such an essential element of the defense without discussing this with her. So then he's allowed to go and talk with defendant, and then he comes back and says, Judge, Ms. Janis says that if her only options are to be dragged into the courtroom, so the victim can identify her, she will stipulate, and then that happened. So yes, we do have the representations of counsel saying she wants to leave, and then we have her conduct actually leaving, and then we have her conduct actually not wanting to return to the court. So again, we have the representations through counsel, explicit and implicit through defendant's conduct.
Do we know from the record what counsel had said to the defendant? I infer, and I think we can reasonably infer that there had been some discussions between counsel and her client. But do we have a record of what exactly counsel may have advised her client about or his client about?
Yes, we do not, Your Honor. All we have is that part of her theory, their theory of defense was that she suffered from PTSD, and that as a result of her PTSD, she acted hyper-vigilant, and that she had acted in self-defense because of her PTSD symptoms.
So my follow-up question is, why shouldn't we treat this case the way we treated Moore versus People and People versus Walker? And in those cases, we said that we dealt with the right to trial and the right to testify. Mm-hmm. And there were challenges to the validity of the waivers of those rights. And we said that those types of claims had to be raised in a post-conviction proceeding because there were going to be some there's going to be information that's not part of the record that's going to have to be elicited on a post-conviction proceeding. Should we treat this type of waiver in the same way?
Well, so the answer is that because here is, let's say, clear and unambiguous from the record that defendant effectuate a valid waiver, there is no need to remand or handle this in a post-conviction proceeding. Yes, if there are any questions or regarding the validity of the waiver or whether it's effective, then the way to address this issue is in post-conviction proceedings. But here we're saying that it was clear because the defendant was present, because the trial court having, present during pre-trial proceedings, pre-trial had seen the defendant and counsel interact. The trial court knew that self-defense and PTSD was part of their trial strategy, and it was clear the defendant did not want it to be present during the victim's testimony. Any question before I?
So I guess, do you object to having this case actually be moved over into a post-conviction context?
I don't think it's necessary, Your Honor. I think this court can determine from this record that this waiver was valid.
But if we disagree with you,
Of course.
then you
yes,
would prefer that
yes,
it be sent to post-conviction?
Yes,
Okay.
absolutely.
Did we make an exception in Moore and Walker for when the record was clear? Or did we just say these are the types of issues that have to be raised in a post-conviction proceeding?
I don't remember exactly. I reviewed those cases, but I think it just wasn't clear from the record in those cases.
Let's assume that we just said that these types of claims have to be raised in a post-conviction proceeding. Do you see a distinction between the rights that we were dealing with in those cases and the right that we're dealing with in this case?
A distinction. So we were talking about the right to waive a jury trial and the right to testify. Well, there is a distinction. As I was saying before, the right to be present is more akin to the right to remain silent because defendant's presence, for example, doesn't have the same evidentiary value as defendant's live testimony. And also defendant's absence from the courtroom doesn't have attached the legal consequences that attach to a decision to testify or plead guilty. For example, when the defendant testifies, he subjects himself to cross-examination, and he could be impeached with any prior felony convictions. And of course, when a defendant decides to plead guilty, there's a long list of legal consequences. So for those, for those cases, for those rights, I guess we require procedural safeguard because of those basics, or the evidentiary value or the legal consequences that attach and that are not something that an ordinary citizen might not know. But the right to be present and the decision to waive the right to be present, simply that I think most ordinary people would know that if you are not present, like in this case for a witness testimony, you will not be able to hear what he has to say. It's not something very or legal or not obvious or like in the other cases. So in that way, it's a little bit different than those rights in Walker and Moore.
Would you, oh, I'm sorry. No, go ahead.
I was going to say, just to follow up on that, would you say then it's the defendant's choice whether he wants to raise this on appeal if he thinks the record is adequate for him to make his case, or to postpone and make an additional record at a post-conviction proceeding?
It's a defendant's choice. Well, I think it should be a defendant's choice, but I think, it would be better if she or he is guided by counsel as to how to proceed.
Actually, I didn't mean to be making a distinction between the defendant and his counsel. Let's say the defense choice. I take it where Justice Samore was going was, I think in Moore and Walker, we said the defendant cannot raise these on direct appeal. They have to be raised in a post-conviction proceeding. You're making a distinction with this one, so would you be saying, and yet I thought I heard you say to Justice Marcus that a defendant would not be barred from going to a post-conviction proceeding. So are you suggesting then it's the defense's choice, if they think the record is adequate, to raise it on appeal, or otherwise to build an additional record on post-conviction?
It is, I think, ultimately, whether the record is adequate or not is ultimately the reviewing court's decision. Unless I'm not understanding your question, but, and of course, if defendant is represented, it's something that should be discussed between the two.
I guess, let me clarify. I guess what I was trying to ask, in apparently a not very clear way, was, were you suggesting that this issue has to be raised based on the record of what happened in court, and that a defendant would be barred from going into a post-conviction proceeding and making an additional record of things that happened outside of court?
Oh, I don't think it should be barred. I mean, defendants can always raise in post-conviction any claim they think they might have, so.
And so presumably, although you're saying this record you think is enough to show that this was an effective waiver,
Yes,
that nevertheless, if the defendant were to go to a post-conviction proceeding on a case like this, and counsel were to take the stand and say, I didn't bother to tell my client she had a choice at all. I just told her she had to leave. Would that then be considered for purposes of deciding whether the waiver was effective?
okay, so your Honor's saying that counsel told the defendant that she did not have a choice to be present at some part of the proceeding?
As a hypothetical, yes.
Yes, well, I mean, I think that would be clear that it would need it to be developed in a post-conviction proceeding.
So you'd be agreeing that evidence beyond what happened in court would be admissible to make a determination whether this was an effective waiver?
Depending on the case, it might be, yes.
Counsel, you would agree that the people have the burden to show a waiver in this instance, right?
Yes, yes.
All right, and that would be by a preponderance?
I think it is a preponderance of the evidence, yes.
Okay.
Or something like that.
So in your mind, what does it mean for the waiver to be intelligent?
All righty. The waiver to be intelligent means that defendant is aware of her rights and makes an informed choice to relinquish a known right. In this case, her right to be present during the victim's testimony.
Do you think her mental condition has an effect on that? And if so, is the record adequate with respect to her mental health?
I think that the record, Your Honor, demonstrates, to begin with, she was found competent twice, okay? I know the defendant raised mental health issues, but her theory of defense was that she suffered from PTSD. And the expert diagnosed her with PTSD. The prosecution's expert, the psychiatrist, did not. And that's something that the prosecution disputed. The expert for the prosecution diagnosed her with mood disorders, substance abuse, and a borderline personality. So that was something disputed. It's not something that is a proven fact because it wasn't submitted to the jury. In addition, I would say that the defendant also talks about all the heavy medications she was taking, but defendant was given a courteous advisement right after the victim testified, and she acknowledged that she was taking many medications, but that she was not under the influence of those medications or alcohol, and the trial court ultimately found the waiver or her decision to testify knowing, intelligent, and voluntary. And that's additional evidence that supports that her waiver of the right to be present was also knowing, intelligent, and voluntary.
How far in advance of trial was the second competency evaluation done?
I do not know from the record. I know there were, I think, part of the record, there were two competencies. I don't know exactly when they were. I don't think that was part of the record. If it was, I don't remember. But there were two, and I believe that she refused another evaluation, a third competency evaluation.
Am I safe in assuming that the second of the two competency evaluations was probably months in advance of trial?
Probably, yes. One a pre-trial and another one maybe right before trial.
And do you think that competency to stand trial is the same as the ability to make an intelligent waiver?
Well, she was found competent means that she did not have a mental or developmental disability that affected her rational and factual understanding of the legal proceedings. So it might be like intertwined with whether she made an intelligent decision, but this court also has to look at the entire record. And this defendant was the defendant that participated and attended all but one pretrial proceedings. She attended or was present during all the other witnesses' testimonies. She also attended proceedings outside of the presence of the jury, including the formal jury instructions conference. She chose to testify, as I said. She also chose to absent herself, alleging that she was very uncomfortable in the presence of the victim, but it was also part of her overall trial strategy, disputed by the prosecution that she acted in self-defense because PTSD. And also, she had waived other rights, like the right to a preliminary hearing or the right to a speedy trial. She was very involved, and then she freely chose not to be present. There's no evidence of coercion.
Well, while you're taking a drink, I guess a couple of things trouble me about this. One is the fact that she has mental health issues, right? And there doesn't seem to be any dispute that she has some mental health problems. The magnitude of those problems may be somewhat in dispute, but she has these limitations in some sense, and yet there's no direct contact with her about how her limitations might affect her decision. It just seems like, given the mental health issues, that the court would have done better, at the very least, to try to talk to her directly about her decision not to be present for a critical stage of the trial. So what's my question? I guess my question is, can you help me feel better about all that?
About the trial court or not? Well, I think as a matter of record, I don't think it was necessary for the trial court to engage in some kind of colloquy with the defendant, because I think it was clear and obvious that she understood her rights. She understood that she had a right to be present during the victim's testimony, and she understood that the victim would testify even without her. I mean, she even refused to return briefly to the courtroom for the victim to identify. Instead, she stipulated to her identification. It was very clear that it was her choice. In addition, and I think I point this out in my brief, after the jury returned the verdict, she wanted to proceed directly to sentencing. And the trial court and the prosecution wanted to have the pre-sentence report. And she had a belligerent outburst, insulting the court and the prosecution because she wanted to go straight to sentencing. And this is additional evidence that this defendant knew what she was doing, and she was making informed decisions. And this is not the defendant who would have sit quietly if she would disagree with any part of the proceedings, much more her own presence at trial. So, but again, you have to look at the whole record from the beginning till the end, everything she did. Not only, even if the score we're not going to believe what counsel conveyed, just look at her actions. Her action clearly and unambiguously demonstrated an intent to relinquish her right.
Would you agree that maybe the better approach would have been to clear the courtroom and have some kind of interaction with her directly as the trial court?
Yes, as I said in the briefs, it seems to be the better practice to engage in some kind of colloquy with the defendant. That definitely will facilitate appellate review. But as this court held in Mosi, I mean, it shouldn't be an essential requirement to find the waiver valid, knowing, intelligent, and voluntary. Like I think in this case, I think it was the trial court had no evidence not to know that what defendant was doing was her free choice, intelligent choice, and voluntary choice. They had discussed the issue before, the first day of trial. They talked about it. It was clear her conduct. She did not want it to be there. So I don't think that the court would have gained much more knowledge by asking, Ms. Janis, you have a right to be here. Ms. Janis, you know that if you decide not to be here, the trial is going to continue. The court already knew that.
I'm on a roll, so I'm going to ask one more question.
Go ahead.
The medications that she was taking, do we know what they were?
Oh, no, I read the record, and it's all kind of medication to help her with anxiety and all that. But she said that she wasn't under the influence, or were not affecting her in a negative way. And that was part of the court's advisement. And the court found that, her decision to testify was not intelligent and voluntary. So regardless of what she was taking, it appears that it was helping, not being detrimental.
Let's see.
Other than knowing that she had the right to be there, to remain in the courtroom for the rest of the trial, what else did she need to be aware of in order for the waiver to be intelligent?
Well, I ponder about that, and I think that if the courts are required to give any advisement, it should be limited to just that the defendant has a right to be present at every critical stage of the trial, and if he or she chooses not to be there, the trial is going to continue. I don't think it would be appropriate for trial courts to provide more specific advisement regarding the consequences that may emanate from particular proceedings, because the consequences might be different if you decide not to be present during voir dire, the witness testimony, closing. So I think that just providing, telling the defendant that she has a right to be there, but if he chooses not to, the trial will continue, is sufficient for him or her to make a valid waiver, a knowing, intelligent, and voluntary. And I guess any other strategic decisions can always be addressed and talked about with counsel. I would like to remain the remainder of my time for rebuttal unless this court has any questions.
Fine. Mr. Lansky.
Hey, good afternoon. May it please the court. Gregory Lansky from Miss Erin Janis. I'm just going to jump right into it. With regards to the 35C issue that Justice Samwer and Chief Justice Coates and Justice Marquez brought up. We're getting that from Moore and Walker, right?
Mr. Lansky, could you move that microphone closer to you?
Should I turn it louder?
Yeah. It's pointing down, so it wasn't getting you.
So
Thank you.
the basis for that is this court's decisions in Moore and Walker. And those cases involved the right, the courteous advisement, the right to testify at trial, and the right for a jury trial, the waiver of a jury trial. But there's a very important distinction between Moore and Walker and in this case. In Moore and Walker, the defendant made a record waiver. There was a record waiver, and the issue was whether it was a misadvisement or incomplete advisement. Here, there is no waiver. There's no record waiver. My client didn't say anything on the record. And never before has this court ever indicated that you have to do a right to be present issue in a post-conviction proceeding. Just last week, this court addressed this issue on direct appeal in Zoll. And prior to that, we have Liu, and never before has that happened in this case. So for now to say we have to raise it in a 35C, there's just no precedent for that. And if you even look at footnote 7 in Moore, it speaks to the burden of proof as to the issues that need to be raised in a post-conviction proceeding concerning a constitutional waiver. You know what's left out in footnote 7? The right to be present. It's not listed there. So there's no notice at any point that this issue needed to be raised in a post-conviction proceeding.
Mr. Lansky, do we have any precedent indicating that a warning in the nature of a Curtis warning is required with regard to the right to be present?
The court's question is whether or not there needs to be an advisement for there to be an effective waiver for the waiver of the fundamental constitutional right to presence.
On the record.
Right, on the record. Obviously, absolutely. The reason why is that there's a number of reasons why for that. Number one, the right to be present is a fundamental, personal, and basic constitutional right. The United States Supreme Court said it's scarcely less important to the accused than the right to trial itself. It indicated it is a leading principle that pervades the entirety of law or criminal procedure. It provides legitimacy to the proceedings. In addition, it's personal and basic to the defendant.
Do you think the United States Supreme Court requires such a warning on the record with regard to fundamental rights, even with regard to the right to testify.
Right, I understand. But the ultimate determination that needs to be made is a knowing, intelligent, and voluntary waiver. The advisement serves a purpose. It creates a record that it was a knowing, intelligent, and voluntary waiver. Everyone in this room has an incentive for there to be an advisement. I do for my client because we want to effectuate her constitutional rights. The prosecution wants it because they don't want their convictions to be overturned. And this court has an incentive. They don't want to waste judicial resources.
But the question is whether we adopt that as a rule in every case. And I guess my question to you is, why do we have to have and I think Ms. Morleta concedes, and Campbell in the Court of Appeals years ago said it's the preferred method, but it's not necessarily required. Now, in this case, and so I'd appreciate you telling me why it has to be. I understand why that may be the best practice. But in this case, why can't we look at the circumstances surrounding it? It's a little troubling to me, and I say this with great respect. It feels like a little gotcha. I mean, in open court, prosecutor says, this needs to be voluntary. Can we ensure it's voluntary? Defense counsel in Ms. Janis's hearshot says, we've already made that record. She leaves. And now you say, oh, she didn't understand. It wasn't voluntary. She didn't know. And then this issue about when she's outside and, does she want to stipulate and he comes back in? I'm not inclined to call the lawyer a liar. I would assume he talked to his client. She said she wanted to stipulate. On those facts, why isn't there a waiver?
Well, there's a lot of issues that were raised in that question. Okay, one, there's assumptions that were made. Now, this was done out on a record. Even the AG, when she gave a direct presentation, she wasn't sure whether those representations by counsel was done on a record or not. The other issue here is it's established that counsel cannot waive the right to be present. Okay, you look at the record that was made on the first day of trial. And what was the record that was made by counsel to the court? Counsel and the expert witness had decided it was in my client's best interest that she not be present, she be removed from the courtroom when she wasn't feeling well, she was having some sort of emotional issues. It wasn't my client's determination, it wasn't the decision. It was counsel and the expert witness's decision.
But then when he went up the second time, when she asks if she can leave, my client is very uncomfortable. I would not think he made that up. And that tends to be supported by what happens next. When she's outside and he has to go ask her if she'll stipulate or come back in, and he says she prefers to stipulate. That sounds like her decision. I mean, my concern is that it's almost like we have to assume counsel lied. You didn't say that, but that's what it feels like.
So there's a chronological order as to what occurred. Counselor first made a representation saying, we want her to be removed if she's not feeling well. Then the defendant afterwards, we don't know exactly what was said because there's no record of it, saying, my client's uncomfortable, she wants to leave. That's based upon counsel's initial representation, their determination, hey, we're telling you, if you're not feeling well, we want you to leave the courtroom. Okay, so that shows that wasn't her determination. Another big issue, which is unique to this case, is that she suffered severe mental illness. Okay, and I think that's not disputed here. In our case, this court's case law is clear. When someone suffers a mental illness, in order to effectuate a known, intelligent, voluntary waiver, there has to be an inquiry, has to be an advisement. It's particularly pertinent in this situation, and that's what Arguello speaks to, right? It specifically mentions that. And then later, this court in Davis saying that a known, intelligent, voluntary waiver is affected by a defendant's mental illness. That's why this court did not adopt the Edwards standard, regards to the waiver of counsel. So in this circumstance, it's based upon the record that was made initially by counsel, knowing that this was going to be done by her mental illness, and the court never addressing her at all, never asking, hey, do you understand the consequences of this decision? You understand you're not going to be able to assist your counsel. You're not going to be able to strategize with counsel. You're not going to be able to be involved in cross-examination. You're not going to be able to be here to respond to if you want to later testify. This was never told to my client.
So what about Ms. Morleto's comments to me regarding the fact that she'd undergone a couple of competency evaluations, and that gives us at least a baseline of information about the extent to which her mental health problems should affect her ability to...
This court made clear in Arguello, there's two different standards. There's one standard for competency, and there's another standard for a known, intelligent, voluntary waiver. That is the basis for this court's decision in Davis why you don't do an Edwards analysis, because you have to take into account a mental illness. So just because someone understands, they may be competent, does not necessarily, it's a higher competence standard in order to waive a fundamental, personal, and basic constitutional right. Another big issue here, too.
I'm sorry, let me ask, on the mental illness piece, do you assume that any mental illness at all affects somebody's ability to intelligently waive? I mean, unfortunately, there are many people in this country who suffer depression. I wouldn't think every time there's some hint that someone suffers depression, they need to be given this lengthy advisement on any issue that they have to waive. But
Well,
that seems to what you're suggesting.
I'm not suggesting that. I'm saying, based upon the record that was made here in this case, that she suffers from severe PTSD, the competency evaluations that indicated she suffered from several other medical disorders. When the court has actual notice of these mental disabilities, then the court should be required to at least address the defendant. That's what happened by the Ninth Circuit Court of Appeals in Christensen. Same situation for waiver or jury trial. They said, you don't necessarily have to, we implore you to do an advisement if you want to do it. But if you're on notice that the defendant suffers from mental illness, then you have to do an inquiry. Okay? So this case is very much about the fair, equitable, and moral treatment about mentally ill defendants than it is for an effective waiver of a personal, basic, and fundamental constitutional right. It's equally concerned here. And regardless what the record may say and not say, the court had a duty. The court has a protective duty, right? To make sure a waiver is valid. That's what the United States Supreme Court opinion in Johnson v. Zepp said. That's what Arguello says. We don't indulge, and we indulge in every reasonable presumption against the waiver of fundamental rights. Yes, Justice Coates, do you have a
I was
question?
about ready to say, you weren't suggesting Johnson v. Zerbst required a warning on the record, were you?
Well, Johnson v. Arguello is based upon Johnson v. Zepp, correct?
Well, I think Arguello is a Ferretta type of case, right?
It's a waiver of counsel, but it's a fundamental constitutional right. And again, I go back to the issue. It's how are you going to show a knowing, intelligent, and voluntary waiver for a mentally ill defendant, when you don't do any advisement, you don't offer any accommodation, you don't tell her the disadvantages of leaving the courtroom. You need to do it. This is what justice is involved. This is a fair justice system. There's a legitimacy aspect of this. If you have a custodial defendant who suffers from mental illness, and the court says, well, she wants to leave for medical reasons, emotional reasons, or for whatever, she could leave. No, it doesn't work like that. You have to inquire. You got to find out why she's leaving. Can you offer an accommodation? And if the court would have done an inquiry, you know what it would have found out? That the person who went on the stand assisted in her rape in an alleyway, punched her in the stomach while she was 7 months pregnant, threatened to stomp her baby out. This is someone who suffers from PTSD. Can you imagine what she was going through in her emotions? The court could have said, Miss Janis, do you want to take a break to compose yourself? Miss Janis, can we put another court officer here, to address your fears? This was never performed. And that's why if this court either remands it to a 35C or evidentiary hearing or does a 35C, we're never going to get to that part. We're never going to show that the court could address these issues.
Well, but let me stop you. But the question that we took cert on is whether a formal written advisement needs to be necessary. It feels to me that the big hole in this case is the communication between counsel and the defendant. What happened prior to them coming in and saying they talked to a psychiatrist? What happened when he went out in the hallway and asked her if she wanted to come back in? It just feels like if there's a mistake that was made here, it was counsel either misrepresenting or not performing satisfactorily.
The trial court has a role in this process. The trial court has to make sure it's their duty. They have a protective duty to do the serious and weighty responsibility to determine
Well,
whether
I think
it's effective
counsel
waiver.
has a duty here too, right?
Both have a duty, but the trial court has a duty, and the court didn't fulfill that duty here.
And just a formal written advisement is all we need.
Not a written advisement. You just.
I mean, a
need to-
formal advisement of some kind.
when I was preparing for this case, I'm thinking, what sort of advisement would be necessary for right to counsel? You look at the Curtis advisement, you look at Rule 23, for the waiver of jury trial. And I think the advisement needs to be what the right to be present protects. And that's the 5th, 6th, and 14th Amendments of the United States Constitution, and Article 2, Section 16 and 25 of the Colorado Constitution. What is that right to protect? the right to be present during all proceedings, that if you're going to be absent, you're not going to be able to assist in the defense, you're not going to be able to strategize, you're not going to be able to communicate with counsel, you're not going to be able to be involved in cross-examination. That should be part of an advisement. Another big concern here is also that when the representation was made, nothing was said as to the length of time she wanted to leave, right? She felt uncomfortable, she wants to leave. We don't know how long she wanted to leave. Maybe she wanted to leave for 5 minutes. And the court never said, hey, Ms. Janis, if you want to come back at any point, you could come back, and this is the way you come back. You tell the court officer. This was never said.
You make it sound like this was all the lawyer, and from my reading of the transcript, the attorney told the judge that he had spoken to Ms. Janis's therapist. He couldn't have done that without her consent or her permission, Ms. Janis's permission. And then at one point, the judge asked, is there a signal that you two are going to have to let me know when she needs to leave? And then he says, I suppose the best way is she can just tell me, and I'll ask to approach the bench. I mean, all of that implies to me that he had talked to her and he was speaking with her about this whole situation and her desire to, or her need to leave the courtroom.
First, I want to address there's fundamental constitutional waiver principles, right? And it's a matter of certainty, not by implication. Everything that's being said here is an assumption. Oh, this is what probably happened. This was likely happened. There's a very strong presumption against the waiver of fundamental constitutional rights. And that's what Johnson Vizep said. We don't presume acquiescence. We indulge every reasonable presumption against constitutional waiver. Any doubt is resolved in the defendant's favor. It's a matter of certainty, it's not by implication. And I think your statement was just that. You made an assumption. Oh, when they spoke to the expert witness, right, she must have been present. We don't know that. She's in custody. They may have made their own, in preparing for her trial testimony, maybe they came up with that assessment. In order to make that determination, the court is making an assumption, which the United States Supreme Court and this court said you cannot do.
I'm not assuming things. I'm just pointing out that the record doesn't seem to support the picture you're painting. You're making it seem, at least the way I've understood your comments, like this is all on the lawyer's part and the client had no input and had nothing to do with it. And I think that there is some information in the record that indicates that that's not quite the case. And I don't know that the case law says that there has to be an express waiver either. I know you were asked a question about does there have to be an advisement, and we've talked about that. Similar question, does there have to be an express waiver? Is there authority that you have that says that a waiver is only valid if it's express, if somebody actually says, I waive my right to be present?
There are two cases. United States Supreme Court, Taylor v. Illinois, footnote 24. It says that the right to be present, listed the right to be present as a basic right that is personal to the defendant and needs a public consent on the record. So you have United States Supreme Court precedents say that. And you have People v. Wingfield, the Colorado Court of Appeals, Judge Taubman, who cited to that in regards to that on-record waiver. Another case relates to the right to jury trial, Rice, I think People v. Rice. There, the situation is similar to here, but even worse than our case, or our case is worse. There, for the waiver of jury trial, counsel said on the record, we stipulate that we're going to waive the jury trial. The court made no comment to the defendant. The defendant didn't say anything.
Sorry, counsel. Here, it's not that the lawyer said we stipulate or we waive, which could be the lawyer making a decision. The lawyer said to the judge, I have spoken with my client, and my client has said she'd like to be out of the courtroom for this testimony. Is that that's not sufficient for it to be the client doing the waiver, not the lawyer doing the waiver?
It's not, because in this case, again, the counsel made the record that counsel and the expert witness made the determination it was in her best interest.
Well, I'm talking about, they said they made that determination that when she felt uncomfortable, she should be given the chance to leave. She then said, I'm uncomfortable, I would like to leave. So at that point.
She's following her counsel's orders, and they said she'll be removed, right? She should be removed. So let's say counsel makes that record. She hears that. I feel uncomfortable. Counsel has told me that if I feel uncomfortable, I shouldn't be here. right? So counsels are making that determination. And another part of the advisement should be like a courtesy advisement part of it. They should say, hey, this right is personal to you. No matter what counsel has said to you or what regards to your right to be present, you have to make the ultimate determination, even if that's against the advice of your counsel. Okay, in regards to Rice, there was no statement on the record regards to the waiver jury trial. And this court said, hey, without a record statement, it's not a waiver.
Wasn't Rice on the basis of a rule that says there has to be a written waiver?
It has to be an oral waiver or written waiver. But that rule was the waiver of a jury trial, right? And that's a fundamental constitutional right. So even though that was shown in the rule, it's the same situation here. Okay, it's still the same thing. That rule is protecting the fundamental constitutional right. That's why that rule has that. And here you have the same situation because you have the United States Supreme Court in Taylor v. Illinois saying has to be a public consent on the record. It listed that. It listed 3 different cases in the footnote 24. It listed the right, a guilty plea, the waiver of jury trial, and the right to be present for a custodial defendant.
Do you think Taylor says anything to suggest there has to be a warning on the record that the defendant is waiving, or simply that there has to be a record that the defendant consented to not be present?
Well, the footnote that says in Taylor v. Illinois, quote unquote, fully informed. Says it there in the Supreme Court case, fully informed. And how is it going to be fully informed? Advisement, inquiry, and on the record waiver.
Just because, I don't want to make a speech, but just because we sort of dancing around this issue about how one goes establishing things, I don't think any of us is challenging that there has to be a waiver of a fundamental constitutional right. The question is, what does the record have to show, the record of trial, and what could be proved outside the record? Obviously, you're very familiar with the Curtis line. There was no doubt that what we were wrestling with was exactly this problem in Curtis, and felt that it had caused all kinds of problems about how you go about establishing this waiver. And so in Curtis, as I've understood it for 30 years, we basically made the decision we're going to solve that problem by requiring a per se warning and a per se waiver and per se reversal for a violation of that or a failure to do it. We've since backed away from that, clearly, Blum and Moore, and we've said it still serves a valuable purpose, but ultimately the question is, was the waiver effective? Was it voluntary, knowing, and intelligent? And that may very well require something outside the record to establish. And that's the reason, as Justice Samore is pointing out, I take it that in Moore and with regard to jury in Walker, we actually said you can only raise this in a proceeding in which we can flesh out those things that would not appear of record. What I seem to hear you saying, and maybe I'm going too far, is you're taking the position that if it is a fundamental constitutional right as to which there has to be an effective waiver, that also means there has to be a warning on the record demonstrating that right. And that seems to me to go beyond even what we've said with regard to right to testify or right to a jury trial. And certainly, I don't think we've ever said anything close to that with regard to right to be present. There's my speech. Now
So my response to your speech
okay.
is that I agree. It has to be a totality of circumstances analysis, and you have to show a known, intelligent, voluntary waiver. And I think what Moore and Walker did after Curtis, Hardin, and Blem and Hardin indicated, say, we're gonna go back from Curtis because there may be things the prosecutor may want to prove something outside the record, even though the court didn't gave all the proper advisements. But what I want to focus on is your, I guess, concurrent and dissenting opinion in Moore. And so even that's maybe the case, the prosecution still has to prove those 5 things, right? Still has to prove those 5 things in Curtis, otherwise it's not going to be an effective waiver, right? So, and that's why you have
I'd like to
advisement.
think I make the law, but unfortunately.
And that's why, that's the purpose of an advisement. Without an advisement, the prosecutor's going to be, in deep trouble, It serves a purpose, the advisement, and that's why we have it. And that's why I'm asking the court, you should do it, especially in a situation where you have a mentally ill defendant.
Well, let me ask Mr. Lansky, you've said that, citing to Taylor, there needs to be an on-the-record statement, an express waiver in response to Justice Samore's question. What about the defendants who are out of custody? mean, the law seems, I thought, was pretty settled. If they just don't show up for court, the court will assume they voluntarily absented themselves, and that's considered a waiver. There's nothing expressed on the record in that case. And under your view, are all those cases wrong?
No, they're absolutely right.
But what's the difference? There's no on the record anything from that defendant who is not in custody and just didn't show up. There's no advisement, there's no nothing. So why is that defendant treated differently than an in custody defendant on your theory?
And the answer to that is you look at the D.C. Circuit Court of Appeals opinion in Gordon, in Cross, and you look at the United States Supreme Court case in Diaz. There's a distinction between someone who is out of custody and someone who's in custody. Someone who's in custody does not have control of their body. You know, Ms. Janis didn't walk out of the room and walk out. She was in custody. Of course, they had to escort her out. That's a crucial distinction. And that's what the Court of Appeals did in this case. Say, hey, we understand, you know, you can waive, and that's a Rule 43, I think, 2A issue. You can waive by just not showing up. But there's different rules, you know, when regards to someone's in custody, you know, when life and liberty is at stake. And that's why you have to have these procedural safeguards.
But I was going on your very strong position. There needs to be an advisement, or, I mean, the person not in custody has the same right to be present as the person in custody. I fully understand the distinction that you referred to. But I just, you know, taking from where you start with this fairly strong, you have to advise them, they have to know. You know, I don't know how if the out-of-custody person just doesn't show up. How do we know it was an intelligent waiver? Maybe they were mentally ill. And that's troubling to me, you know, again, if we start where you are.
Right. Well, I think this case, I understand the court's concerned about that, you know, but we're not dealing with that with this case. And we're dealing by a custodial mentally ill defendant. And under such circumstances, there needs to be an advisement inquiry on the record.
Mr. Lansky, the more you point that down, the harder it is for us to hear you. So, no, up.
Up, I'm sorry.
Attaboy.
That's
all right.
Thank you.
I apologize.
All right.
So I was saying that, you know, this case is different, you know, because it's a custodial defendant, a mentally ill defendant. The court was on notice of this. And, you know, this is a fair, equitable, and moral treatment of mentally ill defendants. You know, who knows what my client was going through at this time? Why did she want to leave? She never had the opportunity, you know, to try to stay. This was the most critical part of her trial. This was her accuser. She was not there to listen to him, to ask cross-examinations, to respond to him. And
Can I, on that actually, can you say a little something about the obviousness of this error? Because there's, I think, a way in which the court might well have thought it was accommodating her, that it stopped everything, allowed counsel to approach the bench.
all right, I only have 4 minutes left, so there's a lot of things to address this question. Number one, just to say if it was plain error, I don't agree this is a plain error case. You know, plain error review has no place in a constitutional waiver analysis. Okay, it's done to protect defendants. That's what Moore said and Walker said. We don't punish a defendant for a lack of objection to an advisement. And the reason why you do that, the same reason which would render a waiver not to be knowingly, intelligent, and voluntarily, would also render the reason why a defendant would not object. Right? So plain error has no place in the constitutional waiver analysis. And to say so, I think it reflects a serious misconception of why we have safeguards when we're waiving a fundamental constitutional right. That being said, the court did have notice. There's a number of Court of Appeals opinions that indicated in Campbell, Price, and then the Supreme Court case in Curtis that said procedural safeguards should apply. You look at the Janis opinion, say they were on notice. But what I want to point out, though, why it was so prejudicial, not only did my client did not have the opportunity to assist, her counsel and to respond. The reason why we have the right to be present on the Sixth Amendment is to make sure that the trial proceedings are reliable, right? Her to be present, to face her accuser face-to-face, eye-to-eye. By my client not being there was no accountability, right, for the accuser to say whatever he wanted to say. He knew that she was not there, so he was free to lie or say whatever he wanted, because she couldn't respond to it. And that's why we have the Sixth Amendment, right, the right to be present. By showing face-to-face, the witnesses or the accuser knows, hey, no, I now have to say something in front of this person. And Ms. Janis never had that right. That's why I think, and I think several other Supreme Courts say this is structural error. This is the error here is unquantifiable and indeterminate. Look at the dissenting opinions in Liu by Justice Lohr and Justice Kirschbaum. Look at the Supreme Court cases from other jurisdictions, Connecticut, New Mexico, Kansas, and Montana. If there's ever an example of structural error, this is it, because it's unquantifiable, it's indeterminate. It affected the basic fairness and framework of this case.
I think if the basis for her absence, if it wasn't obvious here from the record that she knew that this particular witness was coming in and for that reason specifically chose not to be there, your argument might make sense. But I guess I struggle with that here because the whole reason for her leaving was she did not want to face the accuser. She did not want to be in the courtroom during that particular testimony.
And the reason why is because this person, according to her, raped her, helped her in her rape, punched her in the stomach, 7 months pregnant. And it's apparent from the record, too, this is the first time she's facing them after her baby died, or after she was arrested on this case.
Which means she had every reason, or apparently legitimate reasons, to be fearful of being in the courtroom at that time. Didn't want to be there to confront her accuser.
It shows that it was undue influence, why it was not a voluntary waiver, right? For the same reason. That's why it's not a known, intelligent, voluntary waiver, because of that fear. It overcome her. And the court, again, never gave her any accommodations.
But the advisement wouldn't have changed the fear. I mean, court doesn't, it wouldn't have changed that she's fearful of the witness. You're saying that shows, undue influence. I mean, the advisement you're asking for wouldn't change any of that.
No,
Just say, you understand you have the right, you can be here, and you'd be helpful to your lawyer if you're here. Yes, I do. I don't want to be in the room with this guy.
But there's three parts. There's voluntarily, there's intelligent. The advisement goes to the intelligent part of it, and the fear goes to the voluntary part of it. So the advisement has two purposes, right? When she testified, she lost composure of herself. She broke down. And what did the court do? It gave a long break. That could have been done here. It wasn't done. In the end, I have 30 seconds left. I'm asking the court to affirm the Court of Appeals opinion. A lot of things are at stake here. Fundamental constitutional rights, the fair, equitable, and moral treatment of mentally ill defendants, and the public's confidence in the legitimacy and integrity in trial proceedings. Thank you very much.
I can't possibly rebut everything, but just have a few points. The United States Supreme Court does not require a formal colloquy on the record to establish a valid waiver, and that's Taylor in pretty much any case interpreting Taylor. Second, this court is, defendant is asking this court to ignore the record, to presume the irregularity of the proceedings, and to presume that what counsel was not faithfully conveying defendant's wishes. And this court should not do that because the record supports the contrary. My third point is that defendant also says that it was undisputed she was severely ill. I think it was the extent was disputed. The defense expert says she suffered from PTSD. The prosecution expert said something else. And this court, my last point, this court in Zoll, Z-O-L-L, confirmed that this type of error is constitutional trial error subject to harmless error review if preserved or plain error if not preserved. And unless this court has any questions, we ask that the judgment of the Court of Appeals be reversed. Thank you very much.
Thank you. I'd like to thank both counsel for your arguments, very helpful. I guess that concludes our docket for the afternoon. Court's going to be in recess indefinitely.
Court is adjourned.